Welcome back, everybody, to You're Free to Go. We're glad you're with us today, and we have a really good episode for you. But first, I'm happy to be here in the studio with Mark. Welcome, Mark. How's everything going?
Great so far. Enjoying the rain in South Florida.
Sorry about that. I know we should move this to LA. We say that all the time, but only if Ben will come with us. All right. So before we even get into this, I just want to say I hope you had a good time teaching the law students down at University of Miami yesterday.
Yeah, I had a good class with my friend Jimmy Sala, and he is an excellent securities law attorney. He was teaching a class at law school. Asked me to come down and work with him and another attorney on what we call parallel proceedings. I think we may have even mentioned them. In fact, we're going to be talking a little bit about that today in another context.
This is true. Yep. And I know you love teaching as much as I have. I've done a fair amount of it. I know you've done a lot more, but one of the local universities, Lynn University, has me come in a lot. And I really enjoy it. You can make a difference with these young kids who are aspiring to be attorneys or already in law school. And I like to see how their minds are thinking. I like the questions they ask, and I like to actually follow them into their career, which is, a lot of them.
It's great. The only thing I noticed, and I mentioned this to Jimmy Sala, was they're all sitting in the back. Nobody wants to sit in the front. In law school, typically in classes, I remember when I went to law school, so back in the Jurassic period, that you would get called upon by the teacher.
Right.
So you tried to shrink down, you tried to hide,
Yeah.
But his class this wasn't a class we called upon students to answer questions so much. What we call the Socratic method. But nevertheless, they're all sitting in the back
far away, hoping you won't call on them. For our listeners, anyone out there that's thinking about going to law school, Mark referenced the Socratic method. That's basically a teaching approach that all law schools do this. The professor teaches by asking questions. So they don't actually lecture the way you would think in a normal school, college, graduate school, high school, and so forth. They ask a question, and they actually call on a student typically, and that student sometimes has to stand up, but depends on the professor or the law school, or sometimes they can stay in their seat. And the teacher will say, did you read this case? What did it stand for? Who were the parties? And they go through, it could be a 15-minute thing, could be an hour, could be 2-3 hours even, depending on how long the class is. And it's pretty intense and intimidating. So like you said, you hide. I used to hide behind a woman in my class with a bouffant hairdo. I'm like, if I hide behind this 3-foot tall hairdo, the professor won't see me or call on me, which didn't work because our listeners should know, in case they go to law school, typically professors have a seating chart, and they just look at the seating chart and pick somebody out off of that.
Well, there is a tactic that I heard about. I never tried it. But somebody told me when I was in law school, as I said a long time ago, where you even beat the professor to it. You raise your hand when he starts to ask the question. You raise your hand. If you're prepared, you answer it. Then thereafter, he asks another question or she asks another question. You raise your hand again, you never get called on again.
Right. Yeah, that is a good trick. I wish I'd known that then. I remember one student in my class, in all school you can buy Cliff Notes, they kind of have the summary of everything. And they never did their homework, but they always had the Cliff Notes with them. So she got called on once, and she kind of hid the Cliff Notes on her desk. And she got called on, and she was answering the Socratic method, answering every question the professor asked from the Cliff Notes. And about 3 or 4 minutes into it, he figured out that she's definitely reading Cliff Notes. And he walked over to her and he moved her books aside and said, hey, let's see what the Cliff Notes say, So she got burned. A lot of students have a lot of stress and anxiety over it, and maybe even postgraduate law school PTSD, It's an intense experience.
Well, the class I taught for many, many years was trial advocacy. So naturally, they're all performing all the time. They can't shrink because they get up, they do opening statements, direct examination, cross-examination, introducing evidence, and our midterms and our finals were mock trials.
Right.
So, they if they got into the course, they did so because they knew they were going to be doing that.
Right. The truth is, if you're taking a trial advocacy course and you're hiding, then that's the wrong career path for you.
Oh, absolutely.
Right. Yeah. So, all right. Well, let's get into some content today. The last couple episodes, we've started with a question that our fans have been sending in to us, and I think it's been going so well that we might as well do it today again. And so today's question that we hear a lot of from our fans is, if I'm being sued civilly, and remember the difference between civil and criminal, civil's typically about money, criminal's about your freedom. So the question is, if I'm being sued civilly, can my case become a criminal case? So ironically, to tie this together, Mark and I were just talking about how we've taught in law schools and undergraduate programs as well. We actually lecture to law firms, Mark and I do. The law firms that only handle civil and civil litigation in particular will call us in to talk to their civil lawyers and say, hey, we have this civil litigation. What should we know or what should we be looking for to identify if there is a criminal investigation, a criminal investigation behind the scenes watching our civil litigation, almost getting ready to pounce on my client. And so Mark and I lecture to a lot of the law firms around the country in their civil litigation departments on what to look for in a civil litigation. And there are things that we will get into, but if a civil litigation has allegations of some things like fraud or conversion, they're similar. They can be civil and they can be criminal. Just because this case started with these civil claims, we'll identify that, wow, these could be criminal as well. So I know, Mark, you have a story you want to share about one of your cases.
Well, part of this is how do you recognize as an individual or a lawyer representing an individual that that individual may be under criminal investigation. And there are some obvious signs. But one of the things that happens is even if there's no lawsuit, you find out, for example, that your bank is getting subpoenas from the federal government for your records.
Now, will the bank always tell your client that? A lot of times I thought they don't even tell the client.
Well,
their customer.
Yeah, and it varies, but quite often you find out.
Yeah.
Or even if it's not a bank subpoena, a subpoena to your accountant, a subpoena to a business partner, a subpoena to the company that you're working for, a subpoena to somebody who's a friend or colleague. Usually that's a good sign, because if it's a grand jury subpoena, grand juries only investigate criminal cases.
Right, and I think everyone probably knows what this subpoena is, but it's basically an order to provide information or testimony about something.
Right, and it's usually for documents in that vein, but it can be for testimony as well. So I had and what happens, let me just say this, when you get information like that and you know there's a grand jury and it's looking for records or information that may involve you, the smart thing to do is you contact an attorney.
Yep.
To find out what's going on. I had a case recently where a client found out that his records, his bank accounts, were subpoenaed by the grand jury. And so he came to see me, and he was in a small business that they were involved in the securities industry, and he and his partner were speculating and buying and selling penny stocks and pink sheet stocks, really cheap stocks.
Right.
That would high volatility in their in how they would grow or they would deflate. So a lot of those cases are made what we call pump and dump cases.
Yep.
But I'll get into that at another time. In any event, he finds out about the bank, his personal accounts being subpoenaed by the grand jury. So he comes and he sees me. And I tell him that, what I would do is I would contact the bank's attorney, and at least learn the name of the U.S. attorney on the subpoena. Grand jury
right.
subpoena. So there's always a U.S. attorney's name on the grand jury subpoena.
That initial contact and call is important because we can really figure out what's going on here.
Exactly.
Right.
And then once I learned that, I would call the U.S. attorney. Well, I quoted him a fee for that. I don't know what that was.
Right.
But quoted him a fee for that. And he decided, nothing's happening yet. I'm not going to do it. I'm not going to spend the money for an attorney. Okay.
So, in one of our recent episodes, we talked about how we as criminal defense lawyers charge a fee or quote a fee, and we talked about flat fees. But in that situation, you really don't know yet what you're getting
So I
into.
charged him an hourly fee with a
Right.
small retainer to cover what I anticipated would be my time. But he, like a lot of people, human nature being such, they don't want to spend money until they think they have to.
Right. That happens a
Well,
lot. Yeah.
And so what happens is, turns out, unbeknownst to him, the U.S. Attorney sends out a target letter. And target letter that basically says, you are a target of our grand jury investigation. We believe you're involved in X number of crimes, what they are. We're inviting you to come to the grand jury and testify, which, of course, you always decline that invitation.
Right, so-
Always advise clients not to testify in the grand jury.
So at this point, he finds out about the bank, but he decides not to hire you.
Right.
And then subsequent to that, at some point, probably weeks or months later,
A letter goes
a
out.
letter goes out from the federal prosecutor's office to say you are a target. Let's just explain what there's target, there's person of interest, and so forth.
There are basically what has been identified as three different classes that you could be in, or three different statuses you could be in. Target is when the grand jury or the U.S. attorney is really looking to charge you. They believe you are guilty of a crime. They're going to be putting together evidence to support a charge. Then the middle ground is a subject. They're not sure yet. You're possibly under investigation. You may be a target, but they don't know yet. They have to develop more information. And then the third status is to simply be a witness about a crime that they're not charging you with.
Right. So this is your client got he wasn't your client at this point.
He
but,
wasn't my client, and he actually didn't get the target letter.
But I wanted to say that the target's the most serious.
Yeah,
Obviously.
you get a target letter, you know
right. And
you're under investigation.
so, by the way, when clients come into me with these letters, I always say this is a fluid process during this investigation. It's fluid in the sense that you could be a target one day, and then based on our work, maybe you just become a witness for the government or a person of interest or the subject and so forth. Or you could start off just they think you're a witness, and you could become a target. It's very fluid until they conclude their investigation. Now, let's get back to your client.
By the way, in that regard, in explaining it,
Yeah.
because you need to explain it to people, I have a little sort of metaphor that I use, or analogy. I liken it to a dentist's office.
Okay.
Nobody wants to sit in that dentist chair.
Right.
9 times out of 10, it's not pleasant.
Yeah, they said that's one of the top three fears. Well,
Right.
public speaking and going to a dentist are like the two top fears, apparently.
So if you're a target, you're going into that dentist chair.
Right.
If you're a subject, you're in the waiting room. You may be going into the dentist chair. You may chicken out and leave.
Yes.
And if you're a witness, you're just the guy walking down the hallway.
Okay. Good. I like that. That's
You're
crystal clear.
You're never going into that dentist chair.
Right. It's crystal clear. Yeah.
So that letter goes out, but here's where it got screwy. The letter was addressed to him, but there was one number off on the address. Instead of like 1103 X Lane, it was 1105. Apparently, it had gone to the next door neighbor.
I've seen that happen actually when people have cops have a search warrant. They show up and the address.
the wrong house.
They're at the wrong house.
Right.
Which, and sometimes they go in the wrong house, they find cocaine, they arrest the people for cocaine, and then we have an immediate motion to dismiss. It's granted because.
Motion to suppress.
Yeah, and so forth. But anyway, this is more important. Let's hear
So what happens is the neighbor gets this, looks pretty damn serious, but he doesn't recognize the name because my client, the fellow who contacted me, that is, the target, he just moved in a couple of months ago, and they never met. They didn't even know each other's names.
Oh.
So he looked at that, and we found out much later that what he did was he threw it out because he figured it was addressed to somebody who had long since lived there because he was renting, and that place was constantly turning over with new renters.
Right, and I know you and I both have lived in our places for a while. Years ago, I still get mail from people that lived there years and years earlier.
Right.
I wonder, as you share that story, whether if I had got something that said, Department of Justice or however the return label was, if I would have called that the person who signed the letter and said, "Hey, I got this." It's, but I think most people would have thrown it out.
Yeah,
and just
well, he threw it out.
Assumed it was a prior resident.
Right, and it wasn't him.
That's bad luck for your soon-to-be client.
So what happens is, about a month later, 7 a.m., a loud knock on the door. He was lucky that they didn't break it through, but it was a white-collar crime. And a whole bunch of police were there and federal agents, and they arrest him.
They arrest
He's
him.
been indicted.
Wow.
Now he has to hire a lawyer, hires me, and the first thing I find out about the target letter.
That he never received.
That he never received.
Yeah, oh boy.
And I find out that he and his estranged partner, who were running the business, hadn't spoken in about a year. They had a real falling out. The U.S. attorney really wanted the target guy, who became my client now, they really wanted him to testify against the other guy because the other guy had a long criminal record, and they felt that he was much more seriously involved. But because he never responded to the target letter, they wound up going to the other guy, and the other guy's testifying now against my client.
That's what a horrible series of events for your client.
Just
wow.
a cascade of errors and mistakes, but the big mistake was not taking it seriously when a subpoena goes out. So in the context of how you learn that there's a criminal investigation going on, there are obvious signs, even if there's no civil process. Subpoenas, federal agents visiting, coming to your door asking to talk to you, talking to your family, talking to your friends. You learn that they're visiting and interviewing people who are employees of your business. Right. All of those things are signs, and when you get that, the first thing you should do is consult an attorney.
Yes. Yeah.
And take it seriously. Now, we were talking about at the beginning of this thing, the context of there's a civil case going on, and now how do you protect against the possible criminal case that may be lurking in the shadows, a stalking horse? And I want you to tell us about your stories, but one thing I want to point out is prosecutors very often, when they see a civil case going on, if they think it's a real big crime, they may sit back and see what comes out of the civil case, see what the witnesses testify to, what the person who they want to charge as a possible defendant says on a deposition before they surface. Because if they surface, chances are you're going to advise your client to take the fifth in the civil case to avoid giving information that could be used in the criminal case. So tell us about your experience.
Well, you and I have that case right now where this person our client was running what is believed to have been a fraud, where he was taking money from people and running his business, and not really a Ponzi scheme, but it was a financial fraud. But before hiring us, he filed for bankruptcy.
Right.
And what's interesting, like what we could normally do if the civil litigator calls us in and they say, well, our client's got a deposition coming up, we can actually counsel, like you just said, and say, well, he should plead the fifth on these particular questions and so forth, and that will protect him, at least his criminal exposure, hopefully. Once he filed bankruptcy, he was forced to testify, and as a result, the government is sitting in the background watching every time he testifies. They're reading the transcripts. And in bankruptcy, there were a lot of people he owed money to, so they were all suing him. So he had to keep sitting in a chair for deposition with different deposition after a different deposition. And they're just sitting back reading every transcript and putting their case together criminally. So, but yeah, the goal, like you said, is for us, if someone calls us when they think there's a civil matter going on, we can counsel them and counsel their civil litigators and hopefully prevent, and avoid criminal charges. I have a couple little vignettes that I think of. One I see recently, there's a real trend in Florida where, let's back up for a second. Owners of restaurants, the margins are very small. They have a very hard time making a living, even the most successful restaurants. And what they unfortunately tend to do is they may, stop paying their sales tax, or they stop paying their employee payroll tax. So sometimes these restaurant owners, just because they have so little margin that they're, to make profit on, and they're working really, really hard. They're good people, often with no criminal history. They just don't pay the sales tax or employee payroll tax because they have to make a living and be able to pay their own rent and so forth. And so they may get a letter that they show to their accountant, or a non-criminal defense lawyer, saying, "Oh, I got this letter that I owe some taxes. What should I do?" And a lot of times, they just ignore it, or they get bad advice. And then next thing you know, they get a letter saying it's now been referred to the criminal division. And so what happens there is, if they had had the right accountant or right criminal attorney at the beginning, they probably could have worked out a payment plan. But by ignoring it or getting the wrong advice, they ultimately wind up being arrested. I have one of these cases right now, and I was talking to the agent, and they're like, "Yeah, we're doing a ton of these cases right now. For some reason, there's just a trend that they're really coming down hard on these restaurant owners." But now they get arrested in their restaurant. It's totally embarrassing. It's humiliating. It's the painful experience of going through the jail and so forth, the booking process, and it's just really a shame. And then typically, if you have no criminal record, the criminal defense lawyer is able to get involved and work out a payment plan. And it's really a shame because that payment plan could have happened with their accountant or their civil attorney and never ever, and completely avoided the arrest and the embarrassment and now their criminal record. So that's an example of, in a business situation where if they had criminal counsel, they could have avoided it. And now, so that was a restaurant scenario. I have another restaurant scenario, not so much that could have been avoided, but it's just a funny little situation that came up, or to me, interesting. And it goes back to 2016. There was the presidential debate at UNLV, University of Nevada, Las Vegas. It was between Trump and Clinton. So, currently President Trump versus Hillary Clinton in the 2016 presidential debate or election. About 18 months before that, I got a call from an official at the University of UNLV. And they said, "Hey, we just got selected. We're hosting the presidential debate. It's 18 months from now. And we just learned that anyone that's going to be present on campus for the university, any staff, if they have a criminal record, they're not going to be allowed on campus that night." They said, "So we've identified that we have 5 people with a criminal record, and what we'd like you to do is try to get them expunged, get their records expunged, because they told us if the records are expunged, they can be on campus that night." And one of the people, this ties into the restaurant industry, they had actually owned a restaurant several years earlier before going to work at UNLV. Actually, they worked in the food services department, and they had not paid their sales tax, and they got arrested and got a criminal record from it. And so it just shows you how, something like that can actually affect your future, your livelihood, and so forth. And it has a profound impact on your life when you get an arrest. So at this point, the school hired me, and I was able, because they gave me enough notice, because expungements can take a year or so, I was able to get the case, all 5 actually employees' cases expunged.
That were here in Florida, the cases?
No, it was out in Nevada, actually.
Oh.
Yeah, it was UNLV, and I just happened to have a good contact out there that referred it was like the senior vice president of UNLV who was running the campaign for the university, who knew me and called me and asked me to help with that. So another quick vignette that comes to mind that does tie into bad legal counsel was, I call it the parrot case, as in parrot the bird. So we'll call my client named Cassie. So Cassie got a reprimand. She lived in a condominium, and her HOA, her homeowners association, sent her a letter reprimanding her about her parrot and the behavior of her parrot. And ultimately, they were really going to fine her, and she got pretty upset about it. So she hired a civil attorney, and the civil attorney talked to the HOA and the HOA's attorney, and ultimately they agreed to settle this with Cassie writing a letter of apology to a couple residents for the way her parrot was behaving. And in her letter, she admitted that she had encouraged her parrot to bite these other neighbors of hers. So unfortunately, Cassie suffered from alcohol addiction, And when she was struggling or in the throes of her addiction, she would get drunk and she would walk around the halls with her very well-trained parrot and basically walk up to people and say, bite them, bite them. And on a couple occasions, the parrot actually did bite the person. Now, the problem here was this civil lawyer allowed her to put that in writing as an admission of guilt. And now they have the other witnesses from the HOA, the neighbors, who were testifying that the parrot bit them. And that civil lawyer for the homeowners association took it to the prosecutor's office, and they wound up arresting and charging Cassie with the battery on 4 of her neighbors. And had Cassie hired a criminal defense lawyer, he never had that civil lawyer called one of us, we would have said there's no way her letter of apology should have this admission in it, and literally admitting that she encouraged her parrot to bite these neighbors. You really, if there's anything that's in a gray area, you really need advice of counsel. One big case I worked on, actually, that could have been totally avoided if they had good counsel, was a very large developer. He was a very wealthy, successful developer in Dallas, Texas, and he was buying a piece of property for $100 million. So a big piece of property that it was raw land, and he was going to develop it. So he wanted to bring in a very wealthy partner. So he found a billionaire who was not at all engaged in developing. He was a businessman. He didn't know real estate development at all. But the deal was that my client, who was a developer and very successful, would put up 20%, so $20 million, and this billionaire would put up 80% of the purchase price, which is $80 million, and they would move forward to develop this land as 50-50 partners. And part of their deal was that anything going forward, any expense going forward, they would split 50-50. So let's say they're putting in irrigation, and the irrigation was $300,000. Well, my client would put in $150,000, and the billionaire would put in $150,000, 50-50. If they were putting in curbs, building roads and putting in curbs, the bill was $100,000. My client would put in $50,000. The billionaire would put in $50,000. So they were truly 50-50 partners, but for the purchase price. So it was a nice deal to go forward with everybody. And the billionaire was smart. He said, you know what? This is a big investment, even though I'm worth $1 billion or plus. But I'm going to put the billionaire, who was obviously a very bright man, he said, I'm going to put my right-hand executive employee, who's been with me for 30 years, I'm going to put him in your office, and he's going to monitor this investment. It's a big investment, starting at $80 million, and it's going up from there. So I'm going to put him in your office just to monitor this investment and be in touch with it. And my client had no objection to that whatsoever. He thought it was totally fine. So here's what would happen, though, as the case went forward. There would be a bill. Let's say the bill was $60,000. My client would appropriately bill the billionaire, and he'd say, it was $60,000, you owe me $30,000. And maybe another bill comes in for $250,000, so you owe me $125,000. And so it made a lot of sense. It seemed like a very simple way to structure this. But the problem was the billionaire would be really slow at responding. And let's say on the $60,000 bill where he owed $30,000, he'd wait 2, 3, 4 months, and then he'd send them $10,000. And then the $100,000 bill, he'd wait 2, 3, 4 months, and instead of sending $50,000, he'd send $22,000. So not only would he delay, but he would also pay like a third or even less of what was actually owed and what was part of their agreement. So this is why I want to tell you why I told you that the billionaire put this, right-hand man, executive, been with him 30 years, in the office. So my client, the developer, who has $20+ million now into this deal, because he's paying for all these invoices, waiting to be reimbursed 50%, and he's not getting that. He goes to this right-hand man, and he says, what the hell is wrong with your boss? Like, really? And the guy basically says, you obviously didn't do homework on my boss before you entered this deal, but if you Google him, you'll see he's got literally, no lie, like 1,000 lawsuits against him. This is his MO. He puts people in business and then he strangles them financially and he winds up taking the company over. He's done it. Go Google, you'll see 1,000 lawsuits, and that's his MO. That's his modus operandi, which is what he does to everybody. So I'm not surprised he's doing this to you. So he said, well, that really sucks, obviously. So he said to the right-hand man, he said, well, he's your boss. You've worked with him for 30 years. What do I do? How do I handle this? Give me some advice. So the right-hand man says to my client, he says, well, what you do is if you have a bill for $100,000, send it to him and tell him it's $200,000. Then you'll probably get $50,000 because the $100,000 bill, he should be getting $50 from the billionaire. So send him $200,000 bill, you'll probably get $50,000 and you'll be good. Maybe it takes a month, 2 months, 3 months, but you'll at least get your agreed upon 50%. So even though my client wasn't happy about it, it seemed like the right solution because this right-hand man knew his boss inside and out, the billionaire boss, So he's like, fine, that's what I'll start doing. So it worked, kind of well. Unfortunately, it was in a time where real estate, the bottom of the real estate market just fell out. It was a really tough time in the real estate, and this huge project that they were building fell apart and collapsed literally, and there was no opportunity anymore, and they were going to just basically shut it down, and all the money they had put out was going to be lost. So the billionaire, in his typical fashion, went ahead and sued my client, who's a very successful developer, and he sues him, for just the project and giving bad advice. I don't handle the civil litigation at all. He has a civil lawyer, right? So now, and this goes back into our topic, in our question that we're answering today. The civil lawyer says, okay, to my client, before he's my client, you're being deposed in the civil litigation case. And my client tells him, well, this is what's going on with the invoices. And the civil litigator says, well, if his right-hand man told you could go in and what you should do is when you have a $100,000 bill, tell him it's $200,000 and you'll get the money you're owed and so forth. So the civil lawyer says, okay, well, we'll take the deposition and you'll answer the questions and you'll be honest and truthful about them and we'll go from there. Well, you know what happened, Mark. You're a criminal defense lawyer. You see where this is going, and probably our listeners do too. As soon as my client goes in and testifies to what he did, he's basically admitting under oath that, by the way, listeners, a deposition is under oath, and there's a report being taken, a court reporter recording everything, typing everything. It's a transcript. The billionaire civil attorneys took that transcript to the prosecutor's office and said, hey, we got a guy right here lying under oath about a fraud he was committing, creating fake invoices and so forth and so on. Sure enough, about 45 days later, cops show up, like you just mentioned, 7 a.m., which is not unusual. We know that for all you listeners. If there's an open warrant, cops often come at 7 a.m. because they want to catch you.
I've seen earlier.
Yep, 6 a.m., 5 a.m. It's better. It's safer for the defendant. It's safer for the police. It's safer for the community than serving a search warrant when someone's driving their car or walking into an office building or a restaurant or what have you, or a movie theater. So they tend to do it at home early morning because they think they'll catch you a little bit off guard before your day is getting really started. You're still a little bit kind of sleepy and you can't prepare, So that's the most common time. So they go and they arrest him at 7 a.m. And that's when I get hired, of course, and we have to work through this criminal defense case. But if if that civil lawyer had been at a law firm that you and I had lectured at and said, when you're involved in civil litigation, these are the red flags, these are what should send the alarms off in your brain that there could be a criminal case going on, or your client should not testify under oath to certain things, you need a criminal defense lawyer because we could have avoided that. He could have pled the fifth. And so forth, and he never would. It was just so sad. It was because my client was really a victim here, and he did what the billionaire, his partner's right-hand man told him to do, and yet it wound up backfiring on him big way, and he wound up getting arrested and prosecuted.
Wow.
Really horrible.
The example you give is, we're talking about civil lawyers recognizing the potential for a criminal case and advising their client how to proceed, because when a criminal case is looming in the background, and either you know about it or you suspect it, now all of a sudden the dynamics change. You've got to be worried about something that ultimately becomes more important than the civil case. Because when you're dealing with somebody's freedom, and usually in white-collar cases, it's not just freedom. If you're convicted or you plead guilty and you're sentenced, there's a monetary aspect too, just like, if you get sued for the money. So there's restitution, forfeiture. So it's something that you have to really seriously consider. Now, how do you know that there's an investigation going on? There's some obvious signs. But what if a situation exists where you're being deceived? And I have a story about that.
Okay.
Now, if a prosecutor decides to show up at a civil deposition, and that shouldn't happen, and they tend rarely, if ever, to do that. But if they show up at a civil deposition, I mean, you can't get a more glaring sign. It's like a neon sign. Watch out.
Right.
It's a criminal case about to happen. Don't talk.
Yeah.
All right? Cancel the deposition.
Right.
Complain.
Answer your name and date of birth, and then
Now,
and then
smart
assert the fifth.
lawyers, what they will do, if they're taking your client's deposition and you don't want to answer it, you advise them, my client is going to take the fifth. They'll ask questions anyway. They'll identify the questions that you are taking the fifth on. And in federal civil cases, the jury is instructed that they can draw an adverse inference from the fact that the defendant did not answer that question.
Right.
So that's why you want to ask, if you're on the other side and you're suing the defendant, you want to ask all the questions. Well, I had a situation where, unbeknownst to us, the U.S. attorney, I wasn't the civil attorney at the time. I later got involved. But unbeknownst to the civil attorney at the time, the U.S. attorney was sitting in another conference room in the same office suite. Now,
Okay.
what happened is, instead of having a court reporter there, they had an electronic recording system that everybody agreed could be used. And so it displayed it was like a big screen and a camera and a microphone, and it displayed everything that happened, like videotaping.
Sure.
Unbeknownst, and then they were told that a videotape would be made and a transcription of what was said would be done, and they'd have a full record, a video and audio record of what was said at the deposition. Even better than a court reporter.
Right.
But unbeknownst to anybody, certainly unbeknownst to the civil attorney and the civil defendant who later became my client, that was also transmitting to a feed in another conference room in which the U.S. attorney, who was starting an investigation of my client, as he turned out to be, was sitting and watching it. And it gets even worse.
Is there any duty to close that?
Absolutely. Either you're there in person or you're not.
Correct. Yeah.
Now, a transcript could be made of the deposition, and that could be handed to the U.S. attorney. But where the U.S. attorney is right there in the office and he's watching, and there was an additional set of facts, the U.S. attorney had fed questions to the civil attorney suing my client.
Oh, amazing. That's just so underhanded.
So it is so underhanded.
Yeah.
And then what happens is, based upon what was said in that deposition, largely based upon it anyway, the U.S. attorney decides that he's going to file charges and sends a target letter to the client. The client hires me, and I wind up finding out through the court reporter who transcribed and prepared the video for everybody to have, that she provided it to the U.S. attorney who was in the other office at the same time.
That is very, very important information that she
Yeah.
shared, he or she shared
So I
with
went
you.
to the U.S. attorney's office and I said, if you indict, I'm going to get your indictment dismissed. Not only did you act illegally, I think you acted unethically, and I'm going to report this to the bar.
Yep.
We wound up taking a federal plea to a misdemeanor, and anybody out there who's been involved in the federal system knows a misdemeanor plea in the federal system is like a white elephant.
Yeah, you never see them.
It's a unicorn.
Yeah.
There are so few misdemeanors on the books, like impersonating the image of Smokey the Bear, something
Right.
stupid stuff.
Yeah, they just don't have in the books.
Everything else is a felony.
Right. The criminal charges in federal court are typically felonies.
Almost all.
Right.
Universal.
Now, in the state system, about 60% of the criminal statutes are misdemeanor and 40% are felony, but it's 95% the other way.
So rather than litigate a motion to dismiss the indictment because of the conduct of the U.S. attorney, and they offered us a misdemeanor, which was, in that case, going to be probation, no felony record. My client would avoid all the financial costs of litigating. He decided to do that, and so it wasn't turned down. But the point is, that was a very sneaky, underhanded move by the government and by the civil attorney who set that whole thing up.
Right.
Now, the U.S. Attorney's Office, I have found, generally speaking, do not like to be used to help a civil litigant collect their money.
That's been my experience too. I agree.
Right? Their attitude is, and rightfully so, if there's a crime and we feel it's serious enough and we're going to prosecute it, then that's our job. Our job isn't to help you collect money if you're going to have a civil case. Right. And sometimes they decide not to prosecute a case that's on the fence in terms of its seriousness or the evidence, in favor of seeing that there's a civil settlement. If there's a civil settlement and everybody's satisfied, sometimes they'll decide, you know what, justice has been done, we're not going to prosecute. Now, if it's a more serious crime and there's a lot of aggravating circumstances, they will, of course, always prosecute.
Right. Yeah, when I was a prosecutor, I remember cases that were when I was in the white-collar division, which means, business crimes, that if I would get to see that there was civil litigation going on, and later, in months and months after the civil litigation started, all of a sudden they went to the police to file criminal charges and charge you. And I would look at it and say, there's no question when I really looked at it that they were now using the criminal system to bolster their civil case, right? And I could just see how this was going to play out, that they're going to settle the civil case now because of the threat of criminal, and then come to me and say, we don't want to proceed with the criminal case anymore. So don't waste our time, don't waste our resources. I would basically say, as a prosecutor back then, I'd say, pick one or the other. You want us to pursue criminal, we do have charges filed, and we'll pursue that. But you want to go civil, if this is about money for you, then we're not pursuing the criminal. But it was very frustrating as a former prosecutor. I know prosecutors still feel that way. If they feel like the civil attorneys are trying to get criminal charges pursued just to help them win big money in a civil case. So that's definitely something they're sensitive to. It's such an important topic because most everyone in this world at one point or another comes across some type of civil litigation. A small percentage of people wind up in criminal court, but there's a lot of civil litigation. It could be a divorce case, it could be a probate matter, it could be business, so forth. And they really do need to be aware, because you see divorces where sometimes people are hiding money and it starts to come out, or there's every type of civil litigation could have some criminal exposure to it. So it's really important for those civil litigators to call people like us. Now, I don't do much civil litigation. You do a lot more than I do, but people will say to me, "Guy, do you handle civil litigation?" And I say, well, I handle criminal law, and if there's a civil component to it, I definitely get involved in that. I recommend we bring on civil counsel as well. And it goes back to what you were saying a few minutes ago, was that we're usually the captain or the coach or the team owner because you got to put your freedom and your liberty first. So we're the ones that's going to run the show here because your criminal exposes you to losing your freedom.
And unfortunately, and it's just a factor of training and experience, most or many, let's say many, not most, but many civil lawyers, especially civil litigators, are not keen to the signs that may exist or the red flags out there or the indicators that there may be a criminal investigation going on, or what happens in the civil litigation could lead to a criminal charge.
Right.
And you have to be aware of it. So the smart ones, the ones who are experienced, they immediately contact criminal lawyers like ourselves. And then we wind up being in the background usually,
Yep.
but we wind up basically orchestrating how the civil case is going to proceed with respect to being careful to avoid the potential for a successful criminal case.
Right.
And that becomes very, very important. And we do that, you and I do that a lot, and we're consulted by civil lawyers. But, you know, it's an interesting area, and sometimes the interplay between civil lawyers and prosecutors, civil litigators who are suing a defendant, can get a little unholy. And I have one story to tell about that. And I know we're running short of time. So I'm thinking, you know what? Maybe I'll save that for another time.
Okay.
Because it's a fascinating story.
All right, put a pin in it.
I'll put a pin in it.
Yeah, and we'll talk about it next time.
Okay.
But I think this was important because, like I said, a lot of people out there do have civil litigation in their life, and they need to say to their civil lawyer. So all you fans listening, if you have civil litigation, say to your civil attorney, you know, hey, I heard the podcast, and you know they say there should be some consultation with criminal lawyers just to make sure this doesn't go sideways.
In the event that anything comes up that may look like it. And certainly if you're accused of fraud, if you're accused, sometimes the same thing that can be prosecuted criminally can be sued upon civilly.
Correct.
And, you know, if you're a victim of a fraud, for example, you know, you want your money back.
Yeah.
And sometimes you'll go and hire a civil lawyer first, then go run to the FBI or the local police, and then the civil lawyer starts a lawsuit, and the person on the other side, the defendant, well, they're being accused of things that could be a crime as well.
Right.
Their lawyer has to be cognizant.
No, that's a great point to wrap up on that we didn't touch until this last 30 seconds is that, you know, you could be the victim of something and wanting to pursue. You were a victim of a fraud. You hire a civil lawyer. But at that point, maybe you should have a criminal lawyer as well to see, hey, what are my options?
Interface with the government.
Right.
Sometimes we do that. Sometimes we represent victims in order to make sure that the government is following through. Because at the end of the day, the interesting thing is, if the government gets a judgment, first of all, if they get a indictment against someone, and the vast majority of indictments result in pleas, usually, if you're trying to work out a plea, what you will do is you will work out not only the length of a sentence in terms of incarceration, but the amount of money, if you can work it out with the government, that you have to pay in the form of restitution.
Right.
And sometimes paying it up front or paying it quickly or promising to pay it up front or quickly will get you a better deal. In which case what happens is the victim gets their money sooner. So the argument is sometimes the victim is more protected by the criminal system than by the civil system.
Right. Well, there are laws out there that say the prosecutor's highest priority is to make a victim whole.
Right.
So that's why they could get that the defendant, the one who's culpable, can get a big benefit if they get that victim made whole.
And most U.S. attorneys' offices around the country, and this has been of recent vintage in the last 10, 15, 20 years maximum. They have what they call financial litigation units, FLU units.
Yeah.
And they're U.S. attorneys who are specifically tasked with going after the restitution, the court-ordered judgments for payments of restitution or forfeiture.
Yes.
And in the past, 20, 30 years ago, I had a client, he was ordered to pay X in restitution or Y in forfeiture. a lot of times it never gets collected. Now they really go after you, sometimes more vociferously than happens on the civil side.
Right. Well, another great episode.
Yep.
A really good. I know. I wish we didn't have to go, but we'll have another one coming up in a week.
That's right.
Right. So, what do you say, Mark?
I say what we say at the end of every episode. Until the next time, you're
You're free to go.